Thank you, Taxmann, for the invitation for this webinar. This topic is relevant because there is a compliance deadline for this particular topic. And this compliance has been introduced by the government for the last 5 years. I think so somewhere in the year 2018, 2019, the amendment was introduced to the deposit rules, and therefore this compliance has become mandatory. This is a compliance which is generally not an annual compliance which takes place after the annual general meeting, but it takes place annually, but it takes place somewhere in the month of June of every year. So the deadline is fixed, and the transactions to be reported are also fixed. So what I'm going to discuss in this particular webinar is that I will be discussing each and every transaction with a practical, you can say practical case study for each transaction which is mentioned in the company's deposit rules, Rule 2(1)(c), and the exceptions that the deposit has under the particular rule. So I will be discussing that, and then we will be discussing the applicability of the rule and the filing of the form. And also, most importantly, I'll also be discussing the certification of a chartered accountant or the auditor required for such filing of DPT3, whether it is a exempted deposit or a deposit. So we'll just come to the slides for the purpose of discussion. Yeah, so the views are personal and not of Taxmann, since it is a Taxmann webinar, and these are relevant as on today, since company law has been amending for quite a few times. If we check this particular PPT at a later point of time, maybe there could have been some amendment to the provisions. Yeah, so broadly, the agenda for today is this, that we discuss loans, deposits, and debentures as a comparison for the purpose of our understanding. This is quite known, but we need to just discuss or just run through this concept of the comparative analysis. Then there are some exempted deposits. We will be discussing each exempted deposit as far as the time which is there for today's session permits, and we need to identify some important transactions and reporting through the DBT3. So certification is there, the rules have been amended, and the e-form has been introduced. So now there is aging that is required for the reporting to be done. Okay, so we'll come to the first point, which is loans, deposits, and debentures. So more than debentures, sorry. Yeah, so more than debentures, the actual confusion or the conflict is between the loans and deposits. Now we will come to the definition of deposits for the purpose of understanding. So I'll just quickly come. Yeah, this is the definition of deposit. The deposit, it includes receipt of this is the first part is under the Companies Act 2013, and the latter part is under the rules, Companies Acceptance of Deposit Rules 2014. So it includes, so it is an inclusive definition, any receipt of money by way of deposit or a loan or any form by a company. And then there are some exceptions which may be there in consultation with the RBI. And when we come to the concept of exempted deposit, then there again is a reference of deposit, which again includes the receipt of money by way of a deposit or a loan or any other form. And it does not include certain transactions, which is nothing but the exempted deposit. So if you see both the definitions, the concept of deposit or the definition of deposit is an inclusive definition. Secondly, it includes any money taken as a deposit by a company. Thirdly, it also includes any money taken in the form of a loan by the company. So practically, you can say that all loans now fall under the definition of deposit. But obviously, because of the exemption, that is the exempted deposit, it falls under the exempted deposits. That is, you can say, included also and then excluded as well. Then there is a reference which talks about in any other form. Since the first two talk about acceptance of deposit and acceptance of loan, and then it talks about any other form, it will take the color of the first two which we apply the principles of interpretation of jusdem generis, and therefore it will not be any other thing which company accepts as a, you can say, it will not be deposit. So anything accepted by a company will not be a deposit just for the sake of the definition provided here. So this is broadly the definition. So this is basically what is deposit. Now loan is basically you can say a transaction between a borrower and the lender, where the borrower has to pay repay the money at some point of time. It could be in accordance with the agreed terms and conditions, or it could be in accordance with a particular act which is there. So most of the thin line difference between a loan and a deposit is basically, you can say, in case of deposit, there is a particular obligation annexed to a particular transaction. So for example, if we have taken a particular, we can say, a commercial premises on rent, then in that case, we pay a deposit to the owner of the particular property. Now that is not a loan, but it is an obligation to do a particular act in accordance with the agreement. So if we don't comply with the act, or if we default in payment of rent, then the deposit will be deducted. That is not the case in case of loan. Loan is a straightforward transaction between the parties. It could happen that we pay a deposit for when we book a particular hall or a particular for a particular event, right? So in that case, what we pay a deposit, it is not a loan. It is just for a particular transaction that the particular amount is paid, and that amount is a deposit. So that is broadly the difference between a deposit and a loan. Loan, there is a pure transaction of lending and borrowing. And in case of deposit, it may or may not be a pure transaction of lending and borrowing. That is broadly what I have understood between a difference between a loan and a deposit. This difference was important till Companies Act 1956. But considering the fact that we have now the loan included in the definition of deposit, such definition or such distinction is not of, you can say, a great utility, but it just, you can say, helps us in understanding the law and a few related concepts. Maybe under the Income Tax Act or maybe under some other law, this distinction would be important. So this is, you can say, broadly the definition. And when it comes to debentures, the law is very clear. It is a, you can say, acknowledgement of debt. There are no voting rights. In case of deposits also, there are no voting rights. And therefore, it is only the shareholders who have the right to vote. So that is broadly, you can say, the distinction. So when it is a debenture, it is only a debenture in accordance with the debentures provision that we have accepted the money from the debenture holders or the investors. So this is broadly what we discussed, point number 1, which is loans and deposits. In my view, again, just for the purpose of repeating, as of now, there is no distinction between loan and deposit for the purpose of compliance of the provisions of acceptance of deposit rules and the DPT3 that is there. And then we will be discussing all this over a period of time, which is given on the screen, all the points. So in the rules, you can say the rules, that is the acceptance of deposit rules, which is the rules which is applicable, is not applicable to certain class of companies, because they are already regulated in some other manner. So banking company, the non-banking financial company, housing financial companies, and certain companies which are specified by the central government, all these entities are completely out of the purview of deposit rules. So they are not, the provisions what we are discussing right now is not applicable to them. Like for example, there is a finance company in Pune or Bombay or anywhere in India. Like for example, just an example I'm saying, not going by names, but say HDFC Bank or a Bajaj Finance or Manappuram Finance. So these entities may fall under any 1 to 4, and therefore compliance of DPT3 is not applicable to such companies. This is deposits. So we have already discussed this point. Yeah. So now we come to the first, you can say, the first exempted deposits. So whenever a company receives money, and such money or an amount from the state government, central government, or from a local authority, or where they receive a money and such amount is then guaranteed by the state government or the central government, then it would be a exempted deposit. So it is not practically like if an investment is made in the share capital by the government company, then it won't be a exempted deposit. It will be an investment in share capital. But if the money is received in form of a surplus or funds which are received in the form of grants or in some other manner, probably the such amount, depending on what type of the amount is, it will fall under the purview of the exempted deposit. So any amount received from the state government, local government, or the central government, such amount will fall under the exempted deposit criteria. So share capital is not included, or any other amount will not be included. So this is another amount which is generally what we totally in toto we call it as ECB. So any amount received by a company, which is you can say from foreign government, bank, a multi-financial institution, or you can say a foreign financial institution, or export credit agents, anybody, in fact, even foreign body corporates, or a shareholder, or even a person, all these criteria, if they are fulfilled, you can say the lender who is there, who is in the form of a foreign body corporate or a person resident outside India, then all these persons will be, you can say, all this will fall under, if at all it is accepted in accordance with FEMA, then it will be, though it is a borrowing, then it will be, you can say, an exempted deposit under the Companies Act. So any amount. So if specifically, I was just going through the provisions of FEMA deposit regulations 2016. Under that, they have provided who can give a loan to the company who is a non-resident Indian, and you can say person resident outside India, from which account they can provide. So for that, you can refer the FEMA deposit rules 2016 and amended from time to time. In that, they have specifically provided from which account you can give the money. If we receive that money and that money is received as a shareholder or any other person which is specified here, it will be, you can say, exempted deposit under the provisions of Company Law. And also FEMA would be complied. If a company has accepted ECB, then you have to check the compliance of ECB as well for the purpose of the compliance under the Company Law. So that you need to comply, because ultimately it's compliance of FEMA, and if there is a non-compliance, then probably it may or may not be, or you can say, a compliance of the provisions. Yeah. Then it also includes a loan transaction. So if at all the company has borrowed money from any of the following entities, a banking company, SBI, subsidiaries, banking institution under the Banking Regulation Act, or you can say cooperative bank. So all these entities that the company borrows, any amount borrowed or a facility obtained, it will be, you can say, a deposit, exempted deposit under the Company Law. So the most important part over here, which is not provided by the law, is that if a company accepts, typically these transactions happen in, you can say, the rural part of India, or tier 2 city or tier 3 city of India, which is the company accepting money as loan from Pata Sanstha. So in that case, which is Pata Sanstha is a, I'm saying in a Marathi vernacular language, but it could be another type of a loan or lending institution. So the question is whether such kind of institutions are also provided in this particular this. If you see this particular list, it is not provided here, but read with the Banking Regulation Act and the FEMA and the RBI regulations, which are provided in different, you can say, in separate regulations and rules. By reading all those provisions, loan given by a Pata Sanstha falls under the exempted criteria under this. So typically Pata Sanstha in English, it means credit cooperative societies. Since they are not specifically mentioned over here, and in the last point they mention only about cooperative society, that issue may arise in such case. So that would be the case. Yeah, so then we come to the next, you can say an exempted deposit. So there are already quite a few questions. I'm seeing it simultaneously, but I'll take it collectively because everything relate to the separate kind of transaction. So don't worry. In some time, I'll take all your questions which are relating to different exempted deposits. So any amount received as a loan from a public financial bank or a regional financial institution or an insurance company. So if you receive an amount of loan from new assurance company or New India Assurance, then it would be, and if that money is in a form of a loan or a assistance. So financial assistance could be in the form of overdraft. It could be in the form of a cash credit limit. So whatever is outstanding will be reported in the exempted deposit. So even if it is a loan, it falls under the exempted criteria and the reporting becomes mandatory. This is in case of certain companies where they have received money against the commercial paper. So that is a type of a particular transaction. Yeah, this is one of the most crucial transactions for any company, that a company receives money from any other company. But most importantly, the money should be, means the objective of giving such money should be temporary financial arrangement, temporary financial assistance, or it could be financial, it need not be temporary, but it could be a financial assistance or a financial transaction between two companies. So if there is a transaction between a foreign entity and an Indian entity, then this provision is not applicable because it only talks about a company, which is a private company or a public company or a company under the company law, and not a body corporate, which includes a company incorporated outside India. So this is basically what is covered over here. So if the companies are interrelated, means there is a common director or a common shareholder, or both are private and there are common directors. So in that case, provisions of 185 will be applicable because it is ultimately you can say a lending borrowing transaction between two companies, whether a private company or a public company, depending on the applicability of section 185. It may happen that such, not may happen, but it always happens that such transactions will fall under section 185 subsection 2, where it is allowed subject to passing of a resolution by the shareholders, and then the money not being used for other than principal business activity by the lending entity or by the borrowing entity. So all those criteria are there. So 185 we need to comply. 186, yes, if at all 186 is if the transaction is in the kind of borrowing and lending, then 186 of the Companies Act will also apply. Whether agreement is necessary, if it is a transaction where there is, you can say it is a pre-decided transaction, then it is always desirable to have an investment agreement. That's how the most of the corporates have. So investment agreement is desirable. But in a worst case situation, if an agreement is not there, then the agreed terms and conditions over email or a particular communication, they could also be an agreement between the two. But it is always desirable to have an agreement between the parties. If it is for advance for goods and services, then it will not fall under this. There is a separate provision for such kind of transaction, which we'll discuss. And then if at all it is reimbursement, then in such case, it will not fall under the particular intercorporate deposit, because it's ultimately just reimbursement and not given as a part of a loan. So if a holding company makes a payment on behalf of subsidiary company, and subsidiary company reimburses such amount to the holding company, then in that case, it will not be a intercorporate deposit. So please understand, amount received by a company from any other company, it should either be in a form of a deposit or it should be in a form of a loan. That these are the two conditions to identify whether it is a transaction under the exempted deposits or not. So this is a very critical point. Actually, till Companies Act 1956, this was quite open. So quite a few companies had share application money pending allotment for quite a few years, probably for 10-12 years, which was there, and probably senior chartered accountants or company secretaries or cost accountants who are attending this webinar would be aware that for 8-10 years, 20 years, companies just had share application money pending allotment, and this pending allotment had no end to it. So the amendment was introduced in 2014, saying that you have to ensure that you allot the shares within a prescribed time. The prescribed time is basically 60 days from the date of receipt of share application money. And once you receive the share application money, you have to allot it within 60 days, which is provided here. So this allotment should be done within 60 days from the date. Now it could be any type of allotment. It could be rights issue, or it could be any other kind of issue. But typically, if you see section 42 talks about private placement, and there is a specific provision which says that it should be allotted within 15 days from the date of receipt of money. Then in that case, it should be 15 days and not 60 days. So this is a very important aspect. And most importantly, it talks about subscription or to any security. So you take it in the form of shares, preference shares, debentures, stocks, debenture stock, warrants, any kind of transaction. In such case, this particular provision will apply. If the law provides for a shorter duration, then the shorter will apply. If law is silent, typically in the case of rights issue, if you see rights issue, there is no specific provision which talks about within how many days the allotment should be made. So this particular provision says that it should be allotted within 60 days, and therefore it will apply. So please understand that this transaction should be pending as on 31st of March of any year. Okay. If you have received share application money in the month of November and you have allotted in the month of December, then the question doesn't apply at all. It should be, maybe it may happen that you have accepted money in the month of February or March and it is not allotted as on 31st of March. And as on 31st of March, it is still reflecting as share application money pending allotment. Then only the provisions of the you can say reporting will be applicable. If allotment is already made, then the question of this particular clause will not apply. So this is a very crucial aspect in the case of share application money pending allotment. Yeah, so there are quite a few questions, so I'll just come to that particular point, all the questions that I'll come, so don't worry at all. I'm just checking in between because there are around 9 questions that have been received till now. So I hope this particular aspect is clear. There is a point with respect to in 2014, which said that any pending allotment, you do it within a prescribed time, otherwise it will be a deposit. So all these provisions you have to ensure. This is a very strict provision. In fact, any chartered accountant present, he should also ensure that when you are reporting under CARO, you have to also report that the allotment is done within a prescribed time. So only exception over here is section 42 private placement, which talks about allotment within 15 days. The rest all allotments, it talks about 60 days. Also, one more important point. Yesterday, I was just interacting with one of my client companies. They had received money, but that money was received as a share subscription money. So just company got incorporated around 2 months back, and they had brought money from the US, the foreign investor had invested money. So they were asking about filing of a return of allotment. So return of allotment is not required. You need not even allot within a prescribed time of 60 days because it's basically subscription and not allotment. There are 1 or 2 big judgments on this particular point between a difference between allotment and subscription. I think so in the case of Morgan Stanley, there was one case. And in that case, it was held that the difference was observed. So this is a very critical aspect of share application money pending allotment from other laws as well. Yeah, this is the most, you can say, the most important provision for a private company or a closely held company or a group of companies where the amount is received from a director or a relative of a director or a shareholder. I'll also share shareholder. And then there are some compliances that are to be done. Now, most importantly over here, like I'll just go back to the concept of deposit under 2(1)(c) just for 2 minutes. Like if you see the provisions of the deposits under Rule 2, it actually talks about any particular transaction to which a color has not been provided under the company law. Okay, so certain transactions where amount is received by a company, but in that particular case, the amount is not, you can say there is no corresponding provision to the amount received. So typically this amount or a share application money pending allotment. So all these amounts which are open-ended have been plugged by the company's acceptance of deposit rule under the Rule 2(1)(c), right? So what it talks about over here is that any amount received from a person who at the time of receipt of amount was a director of a company. So when it says a company over here, it includes a private company and a public company. So a director of a private company or a public company can give an amount to a company, whether again, obviously it is a public or a private company. And when it talks about a relative, it is only in relation to a relative of a director of a private company. So if you have received, just an example I'm saying, if a public company has received money from relative of a director, it is not an exempted deposit. It is a deposit. Okay. If a private company has received money from director and director's relative, both are exempted deposit subject to the conditions given in the proviso, right? So this is basically what is so if you see this rule, it doesn't talk about shareholders at all. And if you see the rules under Companies Act 1956, which is acceptance of deposit rule 1975, there was a reference of a member. So even members could easily give loan to the company. But now there is a separate provision under company law for members loan. So I'll come to that as well. So just a quick revision, what we just discussed right now. A director of a private company or a public company can give a loan. A relative of a director of a private company can only give a loan and not a relative of a director of a public company, right? And this relative is defined in Schedule 1 and also specification of rules, specification of definition rules. Even there is a reference to this particular. So for example, HUF is defined, like husband and wife is given, son, daughter is given. So there is a list of relatives which is provided in the schedule. So you need to check who are the relatives. Like for example, I just got a particular matter for interpretation which says sister's son, whether he's a relative or not. So sister's son is not a relative. Even son's son, that we need to check if he's a relative or not. So that is how you need to see specifically in Schedule 1. So that is the list of relatives over there. Then the proviso says that a director of a company or relative, that if at all, they need to provide a declaration to that effect that the amount is not being given out of borrowed money. So this declaration is basically depends on the, you can say the declaration given by the director, and we have to ensure that this declaration is obtained. Suppose a director doesn't give the declaration, then it may not fall under this particular clause, because giving declaration is one of the essential conditions of receiving the amount. And as a company, you have to report this in the notes to accounts as well as in the board's report. Like notes to accounts, there is a disclosure, but board's report is also required to be disclosed. So in board's report, we generally disclose the amount of deposit received. So under that, you may mention the amount of exempted deposit received. So it can be an amount, or you can give a reference to the notes to accounts, which is there. That could be the case. But most importantly, again, I'm just coming back. It says any amount received from a person who at the time of receipt of the amount was a director of a relative of a director of a private company. So, for example, in case of a private company, there is a particular director and he has given a particular loan to the company and he has resigned. And after 4 years, the question would be, or 2 years, the question would be whether this is an exempted deposit. So it is subject to the conditions too. First, it should be, the declaration should be taken from him or her that the amount is not from borrowed funds. And secondly, there should be a disclosure in the board's report and obviously in the financial statement. If these two conditions are there, and it can also basically mean the loan is taken today and he has resigned tomorrow, but it is still reflected in the books of accounts that continues to be an exempted deposit. And there are one or two case laws which says that such loan need not be repaid, such loan does not amount to deposit, such loan continues to be an exempted deposit because the compliance was done at that point of time when the amount was received. So this is basically all about the loans from directors and relatives of a director. Yeah, now I come to some important points over here, because these are practical questions which either I have come across or few members or company secretaries or chartered accountants or cost accountants have come across. So therefore, I'm just putting it over here, whatever I got the queries of. Suppose if a director is only the member, then there is no restriction per se, but the important factor over here is that he should give the amount in capacity of a director. If at all he wants to fall under the particular rule 21C over here. So he should fall under this particular clause, then only the provisions will be. If he falls under the member, then whatever is given in the 5th June 2015 notification, that will be applicable. We'll discuss that also. But you need to decide in what capacity he is giving a loan, whether a director or a member. And one more important point is, whenever a company is accepting deposit or a loan, not only deposit, even in a case of in this case, it is a loan. The loan, if it is accepted, then they need to take the approval under section 179. So section 179 talks about, section 179(3) talks about approval of the board of directors at board meeting. So this transaction cannot be done by, you can say, by circular resolution. One more important point over here is, if it is a private company and as company secretary in practice or a chartered accountant or a consultant or a cost accountant, whatever is the case, if you are consulting, then it's better that at the start of the year, you take an approval of the board of directors to borrow money from directors from time to time during the financial year. This could be done in the first board meeting, which we generally do as a practice, because it should not happen that company borrows money, but the resolution under section 179(3) is not passed. So you need to check the compliance of section 179(3) as well. So how to determine whether a particular amount is from borrowed funds or not? This is a bit tricky question because practically you don't know how this amount is borrowed or not, or whether this amount is borrowed. But you can first insist the director to share the sources of funds. If at all it goes into an internal audit or a forensic audit, in that situation, you can ask the sources of funds of the director to give the amount, and then you can take a declaration to that effect. But ultimately, as professionals, you have to rely on the declaration. If he doesn't give a declaration, I'm repeating, it will not be a exempted deposit because giving a declaration is a mandatory condition. So how to make disclosures? You can make, there is no prescribed format, so you can make a disclosure. It could be the outstanding amount as on 31st of March. It could be anything which is there. Whether reporting in board's report required for members unsecured loan? No, not required as such, because members have a different criteria. Can member give loan to the company from borrowed funds? If we see the 5th June notification, as such, there is no restriction or a prohibition that they cannot give. So if it is a member only and giving it in capacity of a member, they may borrow the money from some outsider and then it can be taken by the member and then given to the company. So possible. I am personally aware that certain directors and members have taken personal loan from banks at some 10 to 12 or 15% rate and given that money to the company as loan. So if we are able to give a declaration to that effect, then it is possible. But if it is obviously borrowed, then declaration will not be possible. So in that case, it will not be a exempted deposit. But practically, as an outside professional or practicing professional, it's difficult to actually determine whether how the money is there received by the company unless you go to the source of the money and find out whether it is borrowed or it is out of the personal funds of the director. Yeah, this is now about acceptance of deposit from members of private company. So it could be a limit up to 100% of paid up capital and free reserves and securities premium account, or it could be a startup for 5 years, or it fulfills any of the following conditions. So clause A, B, C talks about that it is not a group company, it is not an associate company, subsidiary company, and it does not exceed a prescribed limit. So this is A, B, C, any one condition satisfied, you can take. Only thing is you have to report this in DPT3, but DPT3 doesn't have the functionality or a provision for reporting. So you can put it in a form of a note, which is money taken from the members of the company. So here it talks about paid up share capital and free reserves and securities premium account. Since it is paid up share capital, it doesn't talk about only equity. And there was recently a judgment of the Delhi High Court, which said that wherever there is, in fact, they had interpreted the term reserves under the company law, and they had interpreted the of paid up capital, paid up share capital. So since there is no reference of equity or preference, it includes equity and preference, and therefore both will be included for the purpose of the exempted deposits over here. Yeah. So we need to report it. We need to report it in. So there are two occasions where such reporting is required. One is to be done under the 5th June notification, and second is under the company's acceptance. Sorry. Company's acceptance of deposit rules. Okay. So I'll just quickly run through few other provisions. It says that money raised by way of secured debentures, or it could be compulsorily convertible debentures or bonds. So only secured debentures or CCDs, anyone will be you can say an exempted deposit. So if it is an unsecured debenture, you may refer to the next clause. But if it is a partly convertible debenture, optionally convertible debentures, then it will not fall under this, and it may be a deposit under the provisions of deposits. So if it is an unsecured deposits and non-convertible and listed on stock exchange, so there are many companies who do this. Non-convertible debentures, they are listed in NCDs. There are quite a few public companies, private companies. In fact, there was an amendment to the definition of listed entity or listed company under the company law to exclude such companies as listed entities because their equity shares are not listed on the stock exchange. So you can refer to that as well. But basically such companies, wherever they have raised the money, they will be an exempted deposit, and in the deposit rules and DPT3, they need to report the same. So here it talks about any amount received from an employee or a non-interest bearing amount. So not exceeding a salary. If we receive an amount from the employee, then it will be an exempted deposit. And non-interest bearing amount is basically an amount held in trust. So any particular transaction that a company does in trust, then the provisions will be applicable here. This is the most crucial, most debated, and one of the most interpreted provisions since 2018 because it talks about advance, and quite a few chartered accountants I am aware of that how do they actually comply with this provision. There is a misunderstanding that whatever is received today, and if it is not either supplied or particular goods are supplied or services are supplied, then in that case, the amount is to be returned. But that is not the case if one or two conditions are satisfied. First, it says that it should be received as an advance. If you have received money in advance and you have accordingly appropriated in the books of accounts, whether towards supply of goods or services, and that is done within a period of 365 days. So basically, accounting and appropriation is done within a period of 365 days, then it doesn't require any kind of return, and that amount also doesn't amount to deposit. But it will amount to an exempted deposit if it is exceeding 365 days. That's the case. But the law doesn't say that you need to go and report it as a deposit under the company law. So just because 365 days have lapsed, it doesn't become a deposit. If you have appropriated and accounted, then in that case, it is no further action is required. I'll just come to an example so that it will become more practical. Suppose a company is selling a huge machine in its particular plant in, say, Gujarat. Okay. Now, if that plant is being sold or it is being set up by the company, then they will be raising an invoice on the other party. That invoice, for example, is say 1 lakh rupees plus GST or 10 lakh rupees plus GST. If the amount is appropriately accounted in the books of accounts as advance, GST is paid to the government, client is recorded in the books of accounts, then it is advance of receipt of supply of goods and services under Rule 21C. Okay. If the amount is received, but you can say you have not accounted it, or you have not appropriated it, or you have not paid the GST, because ultimately GST is in relation to the invoice, then in that case, the accounting is not done, the appropriation is not done, it would amount to deposit. It would amount to deposit. Therefore, the better way is that you adequately appropriate, you adequately account for it, and you have it in the books of accounts. Even more than 365 days, it will not be a deposit at all. Because law doesn't provide over here anywhere about repayment of money after 365 days. It is generally that takes place in the case of construction contracts, because you pay token money at the time of booking a flat, and then after 3 years you get the possession, and then in the interim time you pay the amount. So the initial amount that you pay to the builder, and if a builder is a company, then the provisions become applicable. So all these are very important provisions. Typically in the real estate group of companies, it could be manufacturing companies, it could be hotel industry, because what happens in case of hotels, that they have online booking, they have booking on their website, and you can say the booking can be done on the website of the company, and accordingly the you can say the but if at all the amount is received but it is not accounted, then there is a problem. It needs to be accounted and appropriated in the books of accounts, then it is not a problem at all. I know it's difficult to explain or understand. It's not difficult to explain, but if you have any queries, you can put up over here for 365 days over here. Then there are trade advances. They have given some examples over here. You can go through in the rules, or maybe over here. I can share the PPT as well with the Taxmann, and the same can be circulated. So I'll not go through all, but broadly, 365 days is only applicable to the first deposit and not to subsequent deposit. This is another important point, which is the co-pay. It is not the director's co-pay, but it is the promoter's co-pay. Like typical corporate finance transaction or a banking transaction where the project is, for example, 10 crore rupees, and the bank says that you invest 10%, we will invest 90%. We will give a loan for 90%. If the 10% is given by the promoters as a loan to the company, even if it exceeds whatever is the case, that will still be an exempted deposit because it is granted under this. Most importantly, this is provided of promoter and not of a director. So it could be a person who has subscribed to the memorandum, a person who is referred to the as a promoter in the articles of association, a person who is referred to the as a promoter in the annual return, and person who is in control of business of the company will be a promoter over here. So the loan is bought in accordance with the stipulation of a bank. The loan is provided by the promoters themselves or their relatives or by both, and exemption is only there till the loan is repaid and not after that. So if the loan is repaid in the year 2024 December, and still the amount of 10%, that is 1 crore, is there in the books of accounts in January 2025, it becomes a deposit and not a exempted deposit. But within a reasonable time, you can repay the amount to the promoters, and that will not be a deposit. So you need, these are important for chartered accountants or cost accountants who are dealing with project finance. And this is a very important provision because it is neither director nor shareholder, but it is a promoter. The definition of promoter is given in the next slide. This is under section 2 of Companies Act. Yeah, just 2-3 minutes and I'll come to the Q&A because I know that quite a few questions have come, and the time of 1 hour is there. So these are typically the amounts received by Nidhi companies. It's not a deposit. It's a subscription received for a chit fund. It's not a, you can say, a deposit. And collective investment scheme, if you comply with SEBI regulation, then only it's not a deposit. If you don't comply, then there is a non-compliance, and there are so many entities under the SEBI regulations which have been penalized for collective investment scheme. So please study section 11A of SEBI Act to understand the collective investment scheme, because since they are already regulated in some way or the other, it becomes exempted deposit. So Nidhi companies are regulated under Companies Act, chit funds are regulated under Chit Fund Act, and CIS are regulated under the SEBI Act. So therefore, that is the case. Then you have got non-convertible notes. This is very important because we have seen quite a few startups receiving money as non-convertible notes. Basically, it is it is an amount convertible into shares, depending upon the milestones achieved by the startup. So typically a turnover or a valuation milestone achieved, then only, that is which talks about over here. It says then upon occurrence of a specified event. So if a valuation is achieved or a turnover is achieved or a market cap is achieved, then you can say the convertible notes gets converted into shares. Another important point is that it says that it is 25 lakhs or more. So this is the only provision which talks about something more and not about less. So it is generally 25 lakhs or less or 10 lakhs or less, but it talks about 25 lakhs or more. So anything above that becomes convertible notes, and therefore the provision is there. And any amount received from the AIFs or DVCF, so the domestic venture capital funds, this would be exempted deposit. So any company, private or a public company receiving money from AIF or a domestic venture capital fund or REITs or InvITs, it will be exempted deposit. Obviously, the money introduced in the share capital, that will not be the exempted deposit. It will be a share capital. So I'll just come to some important points in the rules. So we are done with the exempted deposits, rule 21C. So what this provision says is that it applies to the, you can say, it shall be filed for on or before 30th June every year with the registrar or return in e-form DPT3. It says the next point is very critical, which is point number 2, furnished information contained as on 31st March. Please understand, if the financial year of the company is 31st December, 30th September, 30 June, still the information under DPT3 is to be given under 31st March. There is no exception to it. There is no way out to this, but you have to ensure that you report it as on 31st March. Then it says of the year duly audited by the auditor. So practically it means that it should be audited, but it may be happen that the accounting is going on, but the auditor just takes note of the same and he confirms the amount, even though that is fine. And a declaration to that effect is submitted by the auditor in DPT3. This is one of the most crucial aspects for chartered accountants because here it talks about the certification. There is no separate certificate required for exempted deposit. It is just a certification to the e-form and not a separate certificate in a particular format. Okay, this is for exempted deposit. If it is a deposit, then it's completely separate. It's a public deposit. You need to give a certificate under the deposit rules. But if it is a private company, then you need not give a certificate. You can just confirm the amounts, and that is more than sufficient for the purpose of reporting to the any professional, whether it's a cost accountant, a chartered accountant, or a company secretary. This is point. Second point over here is if you see e-form DPT3, the e-form DPT3 can be filled up even without filling up the details of chartered accountant. So it practically means that you need not actually give the details. It need not be certified. So the basic difference or the basic issue is that certification is required under the company law. That is the rules. But certification is not required for the e-form because the e-form can be complete without the DPT3 giving the details of the statutory auditor. So this is important aspect. In my view, my personal view is that attach a note saying that this particular issue that the e-form is being filed without the certification of the statutory auditor, because the ROC should know that we are aware of such kind of a situation. And another important aspect, it is by the auditor. So it cannot happen that Mr. A is a statutory auditor and somebody is a practicing chartered accountant. So he only certifies the form. That is not possible. So whoever is the auditor shall give the certificate, and therefore not certificate, but basically he should certify the e-form. Yeah, so we need to disclose this in the financial statement, whether it is a private company or a public company, we have to disclose this, so it will be taken care. So if we don't comply, then there is a penal provision under the rules. So the penal provision talks about by fine only, so the offense is compoundable. So now we come to the question answers. So, ma'am, is it fine if we take question answers?
Yes, sir. You can take this session. You can take the question and answers.
Yeah. So I'll just come to the question which is given by A and J. Where certain expenses of a company are paid by a director and shown as payable to director is a deposit and can be treated as exempted deposit. And whether company's electricity that is paid by this and same is accounted, is it no? With respect to this point, which says that expenses, so basically reimbursement by company. In my view, you can pay it as reimbursement because it is at actuals. So it will not be a deposit per se. So it is an amount paid by the director on behalf of the company, and the amount has been repaid, but it is at actuals. So that will be, you can say, either reimbursement or exempted deposit. In my view, you can report it as an exempted deposit by the company. So it will be an exempted deposit. Yeah. So there is a question which says, should the closing balance entered in the DPT3 match with the audited balance sheet for that year? Answer to that is ideally yes. But in quite a few cases, the accounts is not complete till 30th of June. I think we will have this problem for this year only. And from next year, since we have got the audit trail, this question may not come in the next year, but probably in this case, for this year, ideally it should match. But if it doesn't match, then there is no solution to it, to be very honest. You can clarify necessary in the board's report if required, or you can just file the form DPT3 now and then whatever is the situation in the month of August or September, you can mention in the financial statements. Yeah, so there is a question which says, do we need to file a DPT3 in case there was an outstanding amount 31st of March 2022, but there is no outstanding as on 31st of March 2023. Considering that there is now opening and closing balance of deposit, is it required to be provided along with aging? In my view, you have to file DPT3 only if it is outstanding as on that particular year. So in the year, if all the 18 transactions are zero, you need not file form DPT3. Means since there is no outstanding. Okay. But if at all, you may file a nil DPT3. That is an option that you have, but not mandatory. Because if you see the e-form actually talks about outstanding amount. And if there is no outstanding, then practically you need not file the e-form. But if at all you are filing nil DPT3, then you can give this particular amount of the closing, opening, and the closing balance. Okay, now there is a question which says this is in the case of aviation industry. Yeah, the 100% amount is received in advance from the customer against fixed number of flight hours that are available for over a period of 2 to 3 years. While the unutilized amount for the unavailed flight hours is shown as advance in the balance sheet, will it be considered deposit? In my view, it will not be considered as deposit because you have already appropriated that amount. Okay. So if I go to the facts which says that 100% amount received from the customer, so since you have received it and it is from a customer and it's most of the time online only, you know the customer, you know the GST, you know the PAN, you know the identity of the person. Even if it is unutilized for 2-3 years, it will not be a deposit under company. This is my personal view. It will continue to be an exempted deposit. It will be reflected in the books of accounts as advance and not as sales or whatever the accounting entry. But it will not be a deposit because most importantly, you should appropriate it and account it within 65 days. If that is done, then even if the amount is for 2-3 years, the provisions of deposit will not apply. Are security deposit considered as deposit for the purpose? So there is a question by Mr. Sushil. He is asking whether security deposits are considered as deposit. So security deposit, there is a provision over here which talks over here. I'll just come to that provision. Yeah, so it is this particular amount, non-interest bearing amount received and held in trust. If it falls under this particular provision, then if it is non-interest bearing, then it will be a exempted deposit. This is the answer to Mr. Sushil, sir. Will the amount of loan received, which is required to be disclosed in DPT3, be inclusive of forex plus interest, or it is only the principal? So it is the outstanding amount. So it is the outstanding amount. So forex plus interest, whatever is outstanding will be reported. So there is a question by Mr. Ashwini Shah, Miss Ashwini Shah. She says that what if the amount is received not in compliance with FEMA, whether it will be treated as deposit and how it will be reported in DPT3. So to answer your question, Miss Ashwini Shah, in my view, the amount will be considered as deposit because it is not in compliance with FEMA, and probably you have to do compounding under FEMA also, depending on which account you receive money, and the non-compliance under the FEMA deposit regulations, which I was referring to. And will it be reported under DPT3? Yeah, it will be reported, and yeah, it would be a non-compliance under compiler. So you have to file the form DPT3 for the return of deposit. Okay. So I move to the next question. There is a question by Mr. Pawan, Chartered Accountant, Mr. Pawan Sabu. He is asking grant received from NGO for the purpose of a recurring capital expenditure purpose. Will it qualify for exempted deposit? In my view, no, actually. The most important question actually in your case, Mr. Sabu, is that who is giving the grant? What are the terms and conditions of the grant? And whether the grant, obviously it is a grant, so whether it is repayable at some point of time. If it is a grant given by a government or a state body or anything like that, then it is exempted deposit. If it is given, I don't know by whom, but I think so some more clarity or some more questions are required to answer this. So, but yes, to answer your question, in my view, broadly, it is an exempted deposit, but I need some more facts for this particular question. Okay. So there is a question by Ms. Ashwini Shah. She says, you mentioned about receipt of subscription money beyond 60 days. So can we say that we can issue share certificates within 60 days, irrespective of the fact that subscription money has been received or not? So what I feel is, I'll just refer to section 56 of the Companies Act, because section 56 talks about the you can say the issue of share certificate. Under that, you need to check whether the compliance of 60 days, 1 month, 2 months is there. So if you see section 56(4), it talks about issue of share certificates. So if you see B clause, it says within a period of 2 months from allotment. So broadly, it is 60 days only. Okay. So again, there is a question by Ashwini Shah. She says asking, can a relative of a director of private company give loan through his sole proprietary firm? Yes, because ultimately sole proprietary firm and the person is not different. In my view, it's one and the same. Like for example, if I am having a sole proprietary firm, Ram Sales, Mr. or Sri Ram Sales, and you don't take a separate PAN for that. So it's not a separate legal entity. So I think if the sole proprietary firm, it can be given. But you have to comply with the other conditions which talks about out of owned funds and disclosure and all. Then there is a this provision says that what happens to an outstanding loan. There is a question which says what happens to an outstanding loan as on balance sheet date received last year. Disclosure. No, I have not understood this. What happens to outstanding loan as on balance sheet date received last year? Yeah, you disclose it in the director's report, you disclose it in the financial statements. There's a question by Mr. Sushil. He says, what is the background behind director not permitted? Yeah, so basically, see, the background is basically directors will keep on taking personal loans from bank and will be keep on funding the company. Okay. Now, it may happen that company is not in a situation to borrow because of its financial status or situation. So company may not repay. If company will not be able to repay the outsider, company will not be able to repay the director, and there will be a default in a significant manner. Therefore, borrowing out of owned funds is allowed. Borrowing out of borrowed funds is not allowed. Loan received last year. Okay. Why director cannot loan? Yeah, I have already explained this. Whether nil return is applicable. See, actually, if you see by the regulations, nil return, you may file a nil return because it ultimately talks about repayment outstanding as on a particular financial year. So if that is the case, if it is outstanding, then only you need to file. But you may file a nil return just for the sake of compliance. What if a private company is incorporated and number of transactions started till date and directors are transferring some funds to meet miscellaneous? Yeah, it will be directors who are providing loan to the company because they are transferring funds, which basically they are giving money. So it will, you have to comply with the rule 2(1)(c). Kindly explain the changes in DPT3 aging. Okay. Yeah, so basically they have introduced aging. So you have to give it for last 3 years opening and closing balance. So that is the only big change. And one change that I explained is about the certification of statutory auditor. So that is there. So these are the only 2 changes. So if 2023 financial statements are unaudited till 30th June, then how to file the net worth? Yeah, I think if you see the net worth is of the previous year. The net worth is not of this year. If you see the form DPT3, the net worth that you have to include is not of the present year. You have to include it of the previous year. See, it says that net worth as per last audited balance sheet. So if you are filing for 2023, you have to fill in the net worth of 2022. You can check the form. Amount to be shown as on 31st March, even if it is unaudited. See, yeah, it is unaudited, I understand, but there should be some confirmation from the auditor that this is the amount. He may not audit it. If 2023 is, yeah. Can company take, there is a question again by Mr. Sushil. He says that can company take loans under exceptional circumstances to run business? What is the sanctity of so many restrictions? So I don't know about the sanctity, but there is no exceptional circumstance by the law. Yeah, so there is a question. It says that if amount received from a foreign company for issuance of unsecured CCD, then it should be 10 years. Yeah, it should be 10 years. It should be in accordance with the rules. Yeah, there is a question by Mr. Pawan. He says that NGO is a small farmers association, autonomous society. Okay. It is registered. The grant is not refundable. Yeah, so if it is a grant that is not refundable, then it's not a deposit or a loan. It's not repayable. So it is not. It is not a loan or an exempted deposit. Can you please repeat the board report? Yeah. So basically, you have to report it in the board's report. The amount that we received from the directors or the director's relative, you have to report it in the, you can give a reference to the notes to account. You can give a reference to the, you can say, financial statements. You can mention the amount. You can give a cross reference to the financial statements. What if company is incorporated and business is not started and directors are bringing? Yeah, I have already explained that part. Interest charged during the year, yes, it will be considered. Okay. Yeah, so there is another question by Mr. Sankar Dinda. How to show receipts and payment of cash credit received from bank in DPT3. So you would have received a final statement that would be the source of it. Can we take net worth of last year? So yeah, I've already mentioned about net worth. It is to be mentioned of last year because that is what the form expects. So there is a question by Mr. Ajay. Advance from foreign company, yes. If you have received an advance from foreign company, you have to comply with two parts. First, you need to comply with the FEMA regulations. If any advance under the current account transaction is there, and then under the company law, that you appropriate the necessary advance in the books of accounts, account and appropriate. Then it says about trade advance received and invoice raised within 365 days, but service rendered should be treated as advance as outstanding as the same is not appropriated. No, see, if you see the basic provision, you have raised invoice within 365 days, but service is not yet rendered. If the invoice is raised, it means it has been accounted, and since it has been accounted and the invoice is raised, it has also been appropriated. In that case, it will not be an exempt, it will not be a deposit, it will be an exempted deposit. Is a CA certificate mandatory for filing? Yeah, so I've already discussed CA certificate is not mandatory for exempted deposit. Is affixing DSC mandatory? If you go by rules, answer is yes. If you go by form, answer is no. So you can attach a clarification to the form, this particular issue, and file the form without certification, because your form can be filed without certification. This is just based on the experience and the MCA technicalities and not based on any legal provision. The legal provision says that you need to certify, but form can be submitted without your certification. So the call needs to be taken by the company and the chartered accountant. In most of the cases, you can file it with a particular note saying that the form is filed without certification to the e-form. Nil return, in my view, is not required because it is only for outstanding amount. So if you have nil return, you need not report. Then it says if opening balance is exempted deposit is there and the same is paid during the year, then it becomes nil. No? In the 6th point, yeah, sorry. 6th point, it becomes the nil return. Yeah. Also, ma'am, the question answers are over. There are quite a few questions which are repeat questions.